by now that it would be easy to tell when someone is an employee. That's important because only employees can claim unfair dismissal and only employees are entitled to statutory redundancy payments. Of course, most of you will be aware, those regular offenders amongst you, because we remind you every year that there are lots of so-called employment rights which don't only apply to employees. Many rights apply to workers. If someone is an employee, then they're also a worker, whether you think they are or not. But they can be a worker without being an employee.
So several of the cases we're going to be looking at in this session arose because the individuals concerned were claiming to be either employees or workers. Obviously, some of the claims succeeded, some didn't. But before we go into the details, I thought it might be helpful just to give you an idea of what sorts of employment protection rights apply to workers and for which they don't need to demonstrate that they're an employee.
One entitlement is the national minimum wage. It isn't only employees who have to be paid the national minimum wage.
And then, as Brian and I were talking about earlier, the right to paid holiday. You don't have to be an employee to qualify for that right. Again, you just have to show that you're a worker.
The same applies to other rights under the working time regulations. For example, the right to rest breaks and the right not to have your working hours exceed a maximum.
I think another one which is sometimes missed is the right not to have unlawful deduction from wages. I think a lot of people assume that that just applies to employees, but no, it applies to workers as well.
And the right not to be treated less favourably on account of being part-time.
Whistleblowing, that's also employees, but it also applies to workers as well.
And last by no means least, all the discrimination laws, so sex, race, sexual orientation, religion or belief, age, disability, etc. None of them require the individual to be an employee.
So I think actually in one sense you could say that unfair dismissal and redundancy are the exceptions rather than the rule. And the last Labour government canvassed the possibility of legislating so that all employment protection rights, including unfair dismissal, including redundancy, apply to workers. And it's an idea which, I suppose, could be raised again, depending on the results of the next election, which we'll look at shortly.
So the first of our cases on this topic is HR Tech Limited and Stack. Mr. Stack was a shareholder and one of 3 directors of the company. He was not paid. He had other business interests, but he spent most of the week working with the company. Along with the other directors, he claimed expenses, which he did so on the same form as employees. He had a company credit card, and he was a member of the staff private healthcare scheme. At one point, draft employment contracts were drawn up, but they weren't agreed, so they didn't actually get signed. The 3 directors then fell out, and the other 2 terminated Mr. Stack's appointment.
And Mr. Stack claimed unfair dismissal. The Employment Tribunal decided that he wasn't an employee and he wasn't a worker because of the absence of any agreement as to how much he would be paid. Now, this case, again, has been all the way through to the Court of Appeal, and they've sent it back to the Employment Tribunal, asking them to have another look at it. Because what they've said is that it might still be possible for there to be a contract of employment in place and that there would be an obligation for them to pay him a reasonable or a fair amount. And at the end of the day, that's going to need more evidence. But it still leaves open the possibility that Mr. Stack was an employee, despite the fact that there was no formal agreement about salary arrangements.
The second case on the subject is Saha and Viewpoint Field Services. The facts aren't that unusual. Ms. Saha was a telephone operator. She worked anywhere between 7 and 43 hours almost every week, but she wasn't obliged to work when she didn't want to, and there was no obligation on the company to offer her any work. This meant there was no mutuality of obligation between the parties, and she couldn't be classed as an employee. When she did work, however, she was required to do so personally, which made her a worker.
Again, another case which deals with the difference between workers and employees, and it's the Pimlico Plumbers and Smith case. Mr. Smith was given a Pimlico plumber's uniform. He was asked by them to work a minimum number of hours per week. But then on the other side of the scales, he had to provide his own equipment, his own tools, and his own materials. He was VAT registered. He also had to arrange for his own insurance in case anything happened, flooded a house, whatever it may be. So that was his responsibility. He also invoiced for payment of his services, and he was responsible for dealing with his own tax. So I think if we ask the question, who here would say that he was self-employed? It's about just under half. Well, another factor actually, which is important, is that Pimlico plumbers, they didn't actually have to provide work if there wasn't any available, which would tend to suggest self-employment.
It's perhaps not surprising that it was decided that Mr. Smith was not an employee. There was no obligation to provide him with work, no obligation on him to accept it. But it was decided that he was a worker, because he was required to perform such work as he did except personally. He worked for Pimlico plumbers, they weren't his clients or his customers. So he couldn't continue with his claims of unfair dismissal and failure to pay notice, but he was able to continue with his other claims of direct disability discrimination, failure to make reasonable adjustments, holiday pay and unlawful deductions from wages.
Then going back to employment law being sexy, because it's probably going to be the only year that we get the chance to say this, so we're going to hammer the point home. But the other thing that's been in the press a lot has been the issue about internships and unpaid volunteers. And that does still give rise to controversy. I mean, one of the big risks for employers who offer unpaid or low-paid work to interns, because they're saying it's work experience, is the possibility that they could actually be classed as workers, and then you could be hit with backdated claims for minimum wage, for example, holiday pay, if it all goes pear-shaped.
An interesting paper with the not-so-interesting title, The National Minimum Wage Volunteers and Interns, can be found in the depths of the House of Commons Library Business and Transport section. The last edition I saw there was dated 29th of December 2014. It's a clear and balanced overview of the current state of the law, and it refers to an employment tribunal case of Vetter and London Dreams Motion Pictures Limited. In that case, Nicola Vetter was given an internship. She was expected to work from 10 a.m. to 6 p.m. Monday to Friday, but she was only paid expenses. She was also asked to supervise others. It was held that she was a worker and that she was entitled to be paid the minimum wage right back to the date that she started.
Final case on employment status that we're going to look at is Clyde & Co. and Bates van Winkelhoff. And this is a case that's been to the Supreme Court, that's the highest court in our land. And they've overruled the Court of Appeal, and they've decided, and it's quite a staggering decision, but even an equity partner in an LLP was a worker, albeit they weren't an employee. So this, in turn, opened the door for Ms. van Winkelhoff to bring her whistleblowing claim against a multinational law firm.
So we've given you a range of cases on this particular subject, and the message is clear. It doesn't take much for an individual to be classified as a worker. Whether it's a company director, an equity partner of an LLP, an intern on expenses only, or a plumber who provided his own tools and was clearly self-employed in every other sense of the word, in that he could choose when and whether to take on work. They were all workers.
In fairness, it's probably the question now is, well, who doesn't amount to a worker for the purposes of these various rights and protections? And the clearest answer that we can give is that it's going to be someone who isn't required to perform the work personally. So, in other words, if they, at their own discretion, can send a substitute to do the work on their behalf, then again, that would indicate that there isn't the mutuality of obligation, and there's no requirement for them to undertake the work, and there's not even the requirement for them to undertake the work personally. But again, you have to be very careful, because if in the arrangement that you have with an individual that you engage on that basis, there's a provision which says, well, yes, you can send a substitute, but we want to be able to approve who that substitute is, or if they have to send somebody from an approved list, for example, then again, the chances are that could be sufficient for that person to still be able to say that they're a worker.
Okay, it's time to change the subject now. You'll all know, I'm sure, that an employer can't make deductions from wages unless the employee has previously consented in writing.
I think you mean worker?
Yes, you smart ass. That consent can be given either as a term of the worker's contract or in a separate agreement which he signed. One common situation which arises is where an individual has signed a training agreement which state that if he or she leaves the company within a specified period or fail to finish the training course, they will be liable to repay the cost. The agreement will typically state that the employer will be entitled in such circumstances to deduct the amount from the worker's wages.
And those were effectively the facts in the Cleave, Link and Bryler case. But in that case, the worker challenged the deduction and they said that making the deduction amounted to a penalty. As a consequence of that, relying on that provision in the contract, because it was a penalty clause, it was unenforceable. So, what's a penalty clause? Well, it's where one party to a contract inserts what is essentially a punitive provision into the agreement, which entitles them to recover money, damages, compensation, but effectively the money that's being taken out of pay. But actually, the amount that's being deducted is disproportionate to what their outlay is. So effectively, it has that punitive effect. Essentially, it's not a sort of genuine pre-estimate of what the employer's losses might be. And as we've said, if it is a penalty clause, that means that it's legally unenforceable. Now, in the Cleave Link case, the company inserted into its contracts an ability to recover in full not only training costs, but also recruitment costs as well, if an individual left early. And that was the maximum loss the company could potentially suffer. So was that a penalty clause? Well, the AAT decided it wasn't, and that actually the deduction was lawful.
The practical point here is to ensure that if you want to be able to recover your training costs and indeed any other associated costs of an individual leaving before you've had the benefit of the training back from them, you can do so. But make sure you have a clear provision in your employment contract. Better still, make sure they've signed a separate training agreement before they start their course. If you send them on more than one course, depending on the wording, you might need to get them to sign a separate agreement. So be a bit careful about that wording and don't leave it to chance.
Okay, moving on. How many times have you heard the expression or the phrase custom and practice? It's something that's used to describe a situation where there's no express provision in a contract, but there is a course of conduct which happens regularly and consistently by the employer, and which something the employees have also come to expect. And if that happens, it can still become then a contractual obligation. And the clearest way, obviously, to prevent being caught out in this sort of way is to make sure that you don't always act in the same way. Another way that you can deal with it is to make sure that you put a provision in the contract which says that this is entirely discretionary.
One matter which can potentially give rise to custom and practice arguments is the payment of sick pay to employees rather than SSP only. Another is the payment of enhanced redundancy. In Allen and TRW Systems Limited, the company had a redundancy policy which provided that it would pay more than statutory redundancy pay, and it specified 3 elements on which it would be calculated. For 3 successive redundancy exercises, it actually paid a further 4th element by way of enhancement. It subsequently realised that the written policy did not entitle employees to this 4th element, but the union argued that the express policy had been varied by custom and practice. But fortunately for the employer, the Court of Appeal said no. It accepted that the company had paid the higher amount without realising that it didn't need to, and in any event, it questioned whether 3 occasions were enough to create a legal obligation by custom and practice.
But it is something to watch out for. And another area where you particularly want to watch out for it is if you're making payments in lieu of notice, rather than asking people to serve out their entire notice period. And I'm sure many of you will have come across situations where you have paid in lieu of notice rather than asking somebody to work out the full notice period. I mean, commonly it can happen in redundancy situations where you feel it's going to be better for the employee to be able to be released early without having to work through what could be potentially 12 weeks worth of notice. But sometimes you come into situations where an employee has got into the habit of always paying in lieu of notice, making a pile-on in every single case. And of course, that is where you have to be careful. And the reason, effectively, is down to tax. It's less so about an employment tribunal. It's more about HM Revenue and Customs, God bless their souls, and the fact that they love to take their pound of flesh wherever they can. Because obviously, if you don't have a provision in your contract which allows for you to pay in lieu of notice, that can allow you to pay the notice element of any compensation payment without a deduction of tax. It's treated differently, or should be treated differently, by the revenue. It follows, though, that if you have a provision in your contract which allows for you to make a payment in lieu of notice, then you're absolutely obliged to deduct tax and national insurance.
So why are we mentioning it here? Well, there is a risk that if you always pay in lieu, particularly in redundancy situations, HM Revenue and Customs may well argue that there's a custom and practice that you will do so. In that situation, they would say that the notice pay has to be taxed just as much as if the person had worked it. So don't get caught out. If this is a potential issue for you, the practical advice is to make and record some exceptions, cases in which you made the employees work their notice and you didn't pay in lieu.
Okay, let's move on to another topic. Now, I'm sure everyone knows that if somebody leaves their employment and they've not taken all of their accrued holiday entitlement, then they're entitled to be paid in lieu for that.
In Vision Events UK Limited and Patterson, the issue wasn't untaken holiday, but untaken flexi-leave. Mr. Patterson was entitled to accrue flexi-leave if he worked overtime. Well, over the years, he worked over 1,000 hours of overtime without taking any flexi-leave. He was then made redundant. Some companies are never happy. He claimed that he was entitled to be paid for the 1,000 plus overtime hours he'd worked on the basis that it was effectively accrued flexi-leave which was owing to him on termination. Well, the scheme itself didn't say what would happen if an employee left in these circumstances, so the company refused to pay it.
Well, he made a claim. How many of you think that he won his claim and that he had to be paid for the extra hours that he'd worked? A few. Well, no, he actually lost. I mean, the accrual of annual leave, that entitlement only arises because that's what the working time regulations say that we have to do. It's also what the directive requires us to do. So the regulations, the working time regulations, only go one way. I mean, if you've got a situation where an individual's left and they've taken more than their holiday entitlement, you can't automatically claw that back unless there is actually a provision in your contracts which allows you to do that. It's not implied. But the same situation applies to flexi hours. Mr. Patterson couldn't demonstrate an entitlement to payment, but it was a fairly close-run thing.
The Employment Tribunal initially found in his favour. He'd worked 1,000 plus hours overtime, and although the scheme was silent on the subject, they found that there was an implied term that he should be paid for all the overtime hours he'd worked. The Employment Appeal Tribunal has said no, but only by a very slim majority of 2 to 1. They went back to the standard law as to when you can imply a term into an employment contract. The test isn't whether it's fair, as the tribunal decided, It's whether it's necessary to make the agreement work in practice. And they found it wasn't necessary in this case, hence Mr. Patterson lost his case.
Okay, we're going to have a quick brief look at redundancy now. Possibly a sign of the times, but there haven't been any real landmark cases on the meaning of redundancy this year. The big case, which is currently in the European Court of Justice, all comes out about the demise of Woolworths. As you'll know, there's a statutory duty to consult with either a recognised trade union or elected workplace representatives where an employer is proposing to make 20 or more employees redundant at one establishment. And the big issue here is the meaning of that phrase, at one establishment. Because if you take each individual Woolworths store, there are quite a few that had less than 20 employees. And if each store was an establishment in its own right, then the employees at that store wouldn't have been entitled to collective consultation. Only the stores that had 20 or more employees in them would. And if that's the case, then clearly it has an impact in terms of protective awards, because protective awards can be paid if there is a failure to collectively consult. So if the correct approach, though, is to look at the company's proposal as a whole, so you look at the whole of the Woolworths group, clearly more than 20 employees involved, and then there would have been an obligation to consult collectively.
So, as Andrew said, the point isn't just academic. If the unions are right, every one of those employees employed by Woolworths would have been entitled to a protective award of 90 days' pay. And it's also going to affect the larger organisations amongst you that have more than one site.
Now, the Court of Appeal has referred this point to the European Court of Justice, and the Advocate General's guidance was published at the beginning of February. And the view expressed is that the word establishment means the unit to which the redundant employees are assigned. So in the case of Woolworths, the individual store. The judges aren't bound to accept the Advocate General's opinion, but they usually do.
We thought we'd mention just two other cases on redundancy. The first is Nichols and Rockwell Automation Limited, and that relates to selection criteria. The company had a team of 11 field service engineers, and it decided to make one of those engineers redundant. Mr. Nichols had been with the company since 1989. From 2000, he'd gone down to 4 days per week. The company embarked on a selection exercise in which they awarded points for 4 different criteria. Firstly, disciplinary record, where 10 points were available for a clear record. Secondly, performance, including flexibility, where 80 points were available. Then they had skills and ability, where 90 points were available. And then finally, competency in role, including product knowledge, for which a whopping 400 points were available.
400 points, that's brilliant, isn't it? I think you could say that those criteria were slightly weighted in favour of a final category. As an aside, you'll appreciate that the purpose of having a selection matrix and scoring is so that you can show that you've objectified the process and that you've made it as mathematical and as objective as possible, so that if people challenge their redundancy, you're going to be able to demonstrate why they scored lowest. I'm sure most of you will have devised selection matrices for redundancy exercises. Would it be fair to say that perhaps by varying the potential number of marks that are given in a particular category, you can influence the outcomes at all?
A disparity in weighting like this one, where one criterion accounts for only 10 marks and another accounts for 400, is, to say the least, odd. And this might have been the view in the mind of the tribunal's mind when it decided that Mr. Nichols had been unfairly selected for redundancy. They decided that some of the criteria were not capable of objective assessment. But the Employment Appeal Tribunal has set aside the tribunal's finding. It pointed out that not every aspect of a marking scheme has to be objectively verifiable. Selection criteria are not, the court said, to be limited to those which can be the subject of a simple box-ticking exercise.
So, actually, a very pro-employer decision, and part of quite a clear trend towards pro-employer decisions, especially in redundancy cases, since about 2008.
Our other redundancy case this year is Safton Borough Council and Wainwright. Mrs. Wainwright was employed as the head of overview and scrutiny. Her colleague, Mr. Pearce, was the head of member services. Under a reorganisation, both jobs were to be merged so that one of them was going to be made redundant.
Formal interviewing is often a route in a redundancy process, so not going through a selection scoring, but actually asking people to come to competitive interview. It's frequently done. It's an alternative route, and this is what happened, obviously, with Mrs. Wainwright and Mr. Pearce. And after the formal interviews took place, they decided Mr. Pearce was the better candidate. Mrs. Wainwright was made redundant. So, I mean, does anyone see anything wrong with that particular process? No, I mean, it's not easy, is it? She did challenge the decision to make her redundant. And the basis on which she challenged it was that at the time, she'd been on maternity leave. And you're probably aware of that specific regulation in the maternity and parental leave regulations, which says that if a redundancy situation arises while an employee is on maternity leave, she's entitled to be redeployed automatically into any suitable alternative employment, if there's any available. So she was entitled to be given the new role, even if she wasn't the best candidate. So the council shouldn't have subjected her to an interview.
And whilst we're on the subject, there can be situations in which a disabled employee who's at risk of redundancy should be given preference over non-disabled colleagues. But if the choice was between a disabled employee and an employee on maternity leave, what do? Well, you should give the latter, i.e. the person on maternity leave, preference and give them the position.
Okay, this is the bit that we know you've been waiting for. It's our update on TUPE, and we don't like to disappoint. So here we go. First case we're going to look at is the Rinder and Rinsberger case. Miss Rinsberger worked as an asset manager for an LLP, and she was responsible for managing Dutch properties in the fund. She had no other duties, no one to supervise her and no one to assist her. So she was the only person that performed that particular task. And it might be helpful perhaps if I remind you what amounts to a service provision change under TUPE. Well, even if you know, I'm going to tell you anyway. But what you're looking for is an organised grouping of employees situated in Great Britain whose principal purpose is the carrying out of activities which will, after the transfer, be carried out by the transferee. I mean, there's actually quite a bit more to it than that, but we don't want to overload you.
Or bore you. When this case went to the Employment Tribunal and ultimately the Court of Appeal, it was decided that the service the LLP was providing and which Rinder took over was the management of the Dutch properties. Ms. Rinsberger was performing those services, and the LLP had deliberately organised the work in that way. Although she was only a single employee, it decided that she was an organised grouping of employees for this purpose. It was important for her because the period of her service with Rinder wasn't enough on its own to qualify for unfair dismissal, so she needed to be able to show that she could count the previous employment with the LLP as part of her continuous period of employment.
Now, it's important in this case that the LLP had organised the work so that Miss Rinsberger only dealt with the Dutch properties. If the LLP had asked her to work on other properties which weren't transferring, or if it was by chance rather than a deliberate decision that she only dealt with that work, then it's quite possible that TUPE wouldn't have actually applied.
And that brings us on to the next case, London Borough of Hillingdon and Gormanley, where the three individuals concerned claim that they should have transferred to Hillingdon Council when it took back in-house the painting and decorating work their family business had been performing under a contract. Although they did in practice work principally on the Hillingdon housing stock, they could be called upon to perform other duties and perform on other contracts. They were not therefore on the face of it assigned to an organised grouping of employees whose principal purpose was to paint and decorate the Hillingdon properties. The key word here is assigned.
Okay, the next case is the Vernon case. This is almost straight out of Footballers' Wives, if anyone remembers that amazing programme. Mrs. Vernon, though, she was in charge of conferences and events for Port Vale Football Club. She transferred to Azure under TUPE in July 2011, but before the transfer, she claimed that she'd been subjected to a series of acts of sexual harassment, and the perpetrator was the football club's sales manager, whose name, any guesses? Mr. Bedding. So, she complained that she was dismissed for complaining about Mr. Bedding's attempts to proposition her and what she described as numerous allegations of harassment.
One of the issues in the case was whether Azure, which had not been Mrs. Vernon's employer at the time of the acts of harassment occurred and had never employed Mr. Bedding, were nevertheless liable for that harassment. And the answer was a resounding yes. So this is a good example of why, in practice, if you're acquiring a business or taking over a contract, you need to find out who you're going to be taking over, whether there are any outstanding grievances or disciplinary action, etc. The transferor is obliged to pass over this information prior to transfer, but more often than not, they don't.
Okay, and that takes us on, you'll be pleased to hear, to the last TUPE case for this year. Another interesting name involving somebody who's evil. But in this case, the transferor failed to warn the transferee that it hadn't paid their employees' salaries in the month before the transfer, and that they were liable to bring claims for unlawful deduction from wages. 131 employees, and the tribunal awarded each of them £500. So a total of £65,500 in compensation for the vets to pay. So quite a sting in the tail. So again, as Marie explained, always sensible to make good inquiries if you're looking to acquire part of a business.